whether the allocation of natural resources, what is the best manner in which it can be allocated, whether auction is a foolproof method. Now, one of the defenses made by the made against the reference was that the allocation it is a rehearing of the matter, of a judicially decided matter. So that matter should not be a judicially decided matter, and it should be a matter that is not involving disputed questions of fact, because you see, this is an advisory jurisdiction on broad principles, on federal principles, on constitutional principles, and it should not be on the basis of facts. It should be on the basis of principles and constitutional importance that needs to be appreciated well in the interest of the country. Therefore, that is the subjective satisfaction of president. The president who shall refer that question, he should be subjectively satisfied. That's all. Question, the Supreme Court cannot go into subjective satisfaction of the president on the existence of a question of constitutional importance or public importance or general importance. But the Supreme Court can definitely refuse to entertain any matter if it is on its opinion a political question. For example, Ram Janmabhoomi case, Qureshi's case, Supreme is Ismail Qureshi. Supreme Court refused to exercise its advisory jurisdiction, refused to give. In the matter of special reference number 1 of 2012, that is the involving the natural resources allocation, one of the main defenses was, why should a Supreme Court sit on appeal, that is indirect appeal made by the government of India through the President of India regarding a matter that I had already given a judicial order. Therefore, the judicial order it covers, that is a law declared. You must understand, advisory opinion can never be the law declared of the Supreme Court. Advisory opinion is not law declared by the Supreme Court. It is advisory opinion. It is, even though having persuasive value, it does not have the binding value. Therefore, one Supreme Court gives a particular judicial opinion, judicial pronouncement on a particular question of law, there is no need for giving another opinion on the same question of law just because it is referred by the President. Therefore, these are the basic things. Political questions, no. It should involve questions of constitutional importance. Of course, Supreme Court will give importance to the fact that in the opinion of the President, a particular issue of constitutional importance has arisen. However, when the Supreme Court is impressed that it is a political question or it involves disputed questions of fact, the Supreme Court may not give the opinion. Therefore, if in case the Supreme Court decides to give an opinion, then it shall send the particular copy to the Attorney General, who shall summon the concerned parties who are necessary for making a judgment on that particular decision. The Supreme Court needs to hear them also. Then the hearing shall commence, and after hearing, the Supreme Court shall give its advisory opinion. So it is better described in the rules. We have to go to the rules part for that. The principles are these. And next 143 is over. Now 144, I told you, Supreme Court judgments, all authorities, civil and judicial, shall act in aid of the Supreme Court judgment. That means Supreme Court judgment is binding on all authorities. Law declared under 141 is binding on all authorities, and all authorities shall take all steps to implement the law declared by the Supreme Court. So now we have covered Article 136, 137, 141, 142, 143 and 144. Now these are the main provisions. And now let us go to the transfer jurisdiction. Transfer jurisdiction, there are under three heads. One is section 25 of the Civil Procedure Code. The other is section 406 of the Criminal Procedure Code. The other is under Article 139A of the Constitution. These are the three heads of the transfer jurisdiction of the Supreme Court. This is original jurisdiction of the Supreme Court, and you see section 25 is in a civil matter. So there is a civil matter, it should involve a matter pending in two high court jurisdictions. Therefore, there is a need for transferring a matter in a high court or a court subordinate to it to another high court. So that is interest of justice. interest of justice should be served. And in case of criminal matters, 406, fair trial, right to fair trial, and apprehension that there will be failure of justice. So these are the two grounds. Fair trial should be affected, and the apprehension that administration of justice would not be possible. On these grounds, a criminal matter can be transferred from one state to another. And the third is where the matter is involving constitutional importance, and you see the same issue, the same cause of action involving the same constitutional importance matter is pending in one or two high courts or several courts or forums, also the Supreme Court. Then the Supreme Court can take all those matters pending before different high courts, before a cause or list pending before it, and hear it together, so that there shall be uniformity of decisions on the particular question of law involving constitutional importance. So 139A. So these are the transfer jurisdiction aspects. And the other question we have discussed transfer, and we have discussed statutory appeals. What are statutory appeals? Statutory appeals, you see, they are not constitutional provisions, they are statutes. In the statute itself, after the exhaustion of a particular forum, remedy before a particular forum, the statute itself provides for appeal to the Supreme Court. For example, in case of Advocates Act, section 37 provides for appeal to the Supreme Court. In case of the Consumer Protection Act, section 23,
yes.
section 23 provides for appeal to the Supreme Court. And like that. There are several statutes that you can please note those provisions and you can apply it. The other is the jurisdiction of Supreme Court to decide disputes in the presidential and vice presidential elections. This is also area of jurisdiction Supreme Court exercises. It is also conferred in the statute, the particular act itself, presidential and vice presidential elections. The statute containing referring to involving that presidential and vice presidential elections. The appeal is given in that statute itself. These are all statutory appeals to the Supreme Court, as opposed to constitutional rights under Article 136. That is discretion. Here it will be heard as a regular appeal. The difference is discretion. Discretion is exercised everywhere. However, discretion under extraordinary jurisdiction is much different from the statutory appeal, where you have a conferred right. It is, I think, actually you are on a better footing, because the conferred right is always better than a discretionary exercise of jurisdiction. Yeah, but you see, you have to convince the court anyhow, and the discretion finally remains in all matters. So these are the areas in Supreme Court practice and procedure. Now I will be discussing on contempt jurisdiction. I was 129. You see, you must understand that Supreme Court is a court of record, and you see all matters are verified and sworn by affidavit. So any pleading that is made before the Supreme Court is of high evidentiary value, and it cannot be you cannot back out of the evidence produced before the Supreme Court, and the pleadings control the matters that are being heard. Therefore, contempt is civil and criminal contempt. These are the two areas of contempt. In civil contempt, it is because of the willful disobedience of the court and its orders. Then the civil contempt is there. In criminal contempt, it is where you have prevented the administration of justice. You have reduced the majesty of law by maligning the administration of justice and the majesty of the courts. See, the majesty of the courts, majesty of the law, rule of law, and administration of justice. The unpolluted stream of justice as delivered by the court should never be polluted by any extraneous influence. That is the basis of any contempt proceeding being initiated. So it shall be a summary power as well as a regulated power. Depending on if it's on the face of the court, a contempt is committed, like any bad behavior, inappropriate behavior, violent, abusive behavior by any client or advocate, then the summary proceeding shall apply. Otherwise, the Contempt of Courts Act is there, provisions are there. They can be initiated under the Contempt of Courts Act, or you can initiate under Article 129 read with the civil with the Supreme Court rules. I have given the grounds, and you see, it's a court of record, and therefore pleadings, if it is if there are any calibration of the pleadings or any false evidence being given, that also will invite contempt. Therefore, contempt is manifold. Civil contempt is willful disobedience. Criminal contempt, I told you, majesty of law should be affected. The unpolluted stream of the administration of justice should be stopped by act of interference with the administration of justice. Then, on the face of the record, contempt. These are the different areas of contempt which you must need to understand. And contempt I have discussed. What else? And principles. See, ratio decidendi, sub silentio, and per incuriam. These are three concepts you need to understand. Ratio decidendi is closely linked with stare decisis. Okay, I think ratio decidendi I had already discussed earlier. Now, per incuriam, ratio decidendi, let me just recapitulate. Ratio decidendi is the basis, the findings, the analysis of the question of law and the facts, the understanding and the basis on which the Supreme Court reaches the findings of the court on the basis of which a particular judgment is decided, a particular list is decided. That is the ratio decidendi. Now, what is obiter dicta? Ratio decidendi and obiter dicta are different. If the particular opinion of the court that does not go to the root of the cause of action or root of the matter before the Supreme Court in a judicial manner, then it is an opinion of the court that is not related to the main cause of action, but any other subsequent matter of legal importance that is not decided upon. Rights should not be decided upon. Rights, if it is decided upon, it is a ratio decidendi. If it is some other matter of legal importance or any definition on a particular legal subject, but does not go to the root of the matter, then it is a obiter dicta. That is opinion of the court. While ratio decidendi is binding, is law declared under Article 141. Obiter dicta is not law declared. It merely has persuasive value. Therefore, the courts below can apply it as they please. It has high precedential value. However, they are not bound to apply it because it has not decided upon a list, it is not law declared, and it is not going to the root of the matter. So, these are the differences between ratio decidendi and obiter dicta. And now, what is per incuriam and sub silentio? Per incuriam is where a decision of the court is made without reference to a key area of law that needs to be compulsorily discussed in that way while making the decision. That means a key area of law limitation or any key adjudication area limitation or any substantive provision of law that needs to be discussed and applied, but was not done. Then the order is per incuriam. That is, it is vitiated by error. It is vitiated by error because particular important legal principles and concepts and statutes that compulsorily need to be applied before arriving at a decision was not done. Sub silentio is where the Supreme Court is silent on a particular subject that needs to be discussed. It can also lead to per incuriam, where that subject could not have been missed, could not have been ignored. Then it is per incuriam. So, per incuriam and sub silentio are crossing each other. Ratio decidendi and obiter dicta are parallel. They don't cross because for ratio decidendi, it goes to the root of the matter and it decides a list. That is, it should decide a dispute. Then only it is ratio. Obiter compulsorily will not go to the decision on the list. Therefore, you cannot call it a ratio, because it adjudicates some other legal importance matter where discussion has been done, and it is of great persuasive value. That's all. So these are the subjects so far as practice and procedure are concerned. Drafting, I will be discussing 2016 question paper. You see, drafting, there cannot be any lecture. For drafting, you must be good in Supreme Court practice and procedure. You must first know what are the grounds that can be raised, what are the principles that can be applied. And since in SLPs it is extraordinary jurisdiction and substantial question of law and miscarriage of justice, interest of justice, ex debito justitiae, then abuse of process of law, then natural justice failure to give a speaking order. These are all several grounds in an SLP. In writ, see, you must, drafting is nothing but the grounds. In SLP, what you can raise, I told you these grounds. In writ petition, what you must show, how it is different from a PIL. Writ petition is, if it is your interest that you are raising, any fundamental right violation with respect to your own self, then that is a writ. When you are enlarging your locus, idea of locus, and when you are not the affected person, but when you are appearing on behalf of other affected persons, socially disadvantaged sections of the society, pro bono publico, that is in the interest of public, then it is a PIL. So writ is on your own fundamental right violation or the fundamental right violation of the public. It was expanded by S.P. Gupta versus Union of India, where the lawyer is a model citizen and he definitely has locus to question for disadvantaged sections of society. In MC Mehta, there are scores of orders in MC Mehta. These are all PIL. In M.L. Sharma, in Prashant Bhushan's common cause. These are all areas where a registered society or a private citizen or a lawyer takes up public issues and raises it on behalf of the public. The other is one main important public interest litigation principle, in so far as locus of a private citizen is concerned, was discussed in Subramaniam Swamy versus Manmohan Singh. In Subramaniam Swamy versus Manmohan Singh, the Supreme Court held that in Subramaniam Swamy versus Manmohan Singh, the Supreme Court had held that the private citizen has a locus standi to question public corruption, to question areas of policy, and he needs to be answered, and access to justice and proper reply and proper responsible functioning of the government authorities is a must, and the court shall enforce it. Therefore, in PILs there has been expansion of jurisdiction, expansion of locus, and expansion of persons who can come and appear before the Supreme Court under Article 32, and they can interpret on 142 and get the Supreme Court to do complete justice. So this is the PIL. So these are the case laws, important case laws with respect to writ and PILs. In so far as transfer is concerned, there must be miscarriage of likelihood of miscarriage of justice, likelihood of denial of fair trial, apprehension that justice will not be done in criminal matters, and in civil matters it's the interest of justice. It is section 25 CPC. So you must show that a particular transfer of a matter from one place to another is in the interest of justice. There must be sufficient cause and reason for a transfer. That has to be explained. So these are the grounds. So on these grounds we have to draft the questions, draft the paper. Whatever questions are asked, you have to draft. So you are mainly asked in writ, either writ is asked or SLPs are asked. SLP I told, transfer petition is asked, and interim applications, intervention applications are asked. In intervention, you very well know that you cannot claim any relief yourself. You can support or oppose a particular cause of action. Therefore, that is intervention. In impleadment, you must show that you are a proper necessary party. If you are asked to draft a application for condonation of delay, then you must show sufficient cause. These are all terms, key terms you have to use, and key grounds. Sufficient cause. What is sufficient cause? That is a reasonable cause. A reasonable man would have taken to approach the Supreme Court without delay. And if so delay happens, a reasonable man would have done only this much amount of delay. Then that is a sufficient cause. Then you have the impleadment of legal representatives on the death of a particular petitioner or respondent. It is a duty of the advocate on record for the petitioner to bring the notice of the death to the court and seek substitution of the legal representatives of the deceased, because without them the order cannot be final. Their participation, they are proper necessary parties in the litigation, therefore their participation is necessary. Therefore that is LR application. These are all interim applications. And stay. In stay, what are the grounds? So if you are drafting a stay application, either within a SLP or a separate application, then what are the grounds? There are no defined grounds. You see, in stay there is likelihood of miscarriage of justice if an interim order is not passed. The cause of action itself will become infructuous if the interim order is not passed. The locus, the convenience, balance of convenience is in the favor of the person who is seeking that relief. Then there is the need for interim relief. These are the grounds: balance of convenience, likelihood of miscarriage of justice, and interest of justice. And how? You must explain it. So these are the grounds on which you can get an interim order. So if you are not passing an interim order, the entire matter becomes infructuous, like in tenancy matters. So if the tenancy is not protected, if a eviction petition is pending and SLP is pending, unless the SLP stays the impugned order, the possession will go. Once the possession is gone, there is no further need for litigating, because possession is gone means the right is gone. So then for the protecting the cause of action, the interim order is necessary. That is what you need to show in the any interim application for stay or para 8. That is, within the SLP itself there is para 8 under form 28. You have to show the grounds. These are the grounds that are mainly used for getting an interim order. Now there are the counter affidavits. Then you are required to draft counter affidavits. So if you are required to draft a counter affidavit, half an hour. If you are required to draft a counter affidavit, then you are required to oppose. First you have to make the preliminary objections on jurisdiction, maintainability of a SLP. These are the preliminary objections. Then you have to go on the question of law and any facts that are not placed, any facts that are relevant to the case. These are all preliminary objections. See, these facts were not placed in the SLP. If they were placed, no notice would not have been issued. Like that. After the preliminary objections, you have to go to the question of laws that are raised by the petitioner, and you have to say that the question of law is not there. The decision is already made, and the application of the question of law by the High Court in the impugned order is correct. Therefore, there is no perversity, there is no miscarriage of justice as a result of applying a particular settled position of the Supreme Court, and there is also no need for appreciating by the Supreme Court again, because there is no need for interference by the Supreme Court. So therefore, you will be seeking a dismissal of the SLP on the basis of erroneous questions of law and grounds raised by the petitioner. So this is a counter affidavit. Then in case of applications under the contempt, it's under the Contempt of Courts Act, and it's also under the order of the Supreme Court. In case of willful disobedience, you can file a contempt petition in the main matter and show that there is in case of willful disobedience, you have to file a contempt petition citing the order of the court that that was not obeyed by the respondent, alleged contemptor, and you have to name that alleged contemptor, and you have to file an application for contempt. So this you have to raise what is the order that was passed by the court, and what is a disobedience, what is a non-compliance. On getting that point, a contempt petition is grounds are maintainable. The contempt petition is maintainable. So the disobedience of the court is a main ground for a contempt petition in a civil matter. Like this criminal matters, contempt petitions, they are usually not asked. I already that you have to go for the grounds are there. That is polluting the stream of justice. The court's majesty should be reduced in the mind of the public, good thinking members of the public, and administration of justice should be prevented. These are the grounds for criminal contempt. Read with the Contempt of Courts Act, you can find an application after the permission of the Attorney General, and they are prescribed. But mainly, what you are asked in drafting papers is SLPs, civil and criminal. Yeah, writs, yeah, definitely. Some transfers and lots of miscellaneous applications. And also 11.6 application under the Arbitration and Conciliation Act for appointment of an arbitrator in international commercial arbitrations, where it is an international commercial dispute and where there is a need for appointment of arbitrator specified under the agreement. Then the Chief Justice designate or the Chief Justice himself shall appoint the arbitrator on the application under 11.6. There was a question of whether it is an administrative act or a judicial act. In SBP Oil Company, which is a leading case, it has been decided that it is a judicial act. Therefore, you have to apply under 11.6 of the Arbitration and Conciliation Act, citing the arbitration clause and the dispute and the invocation of arbitration clause by way of notice, and for appointment of the arbitrator. So these are the grounds on which these are the portions you have to mention in a 11.6 application. Now let us go to the how you have to answer the question. Now grounds, the grounds you must know. I told you there are several grounds. On these topics I told you, you have to research yourself and get citations where the interest of justice is defined, where substantial question of law that merits interpretation of Supreme Court is defined, where need for interference by the Supreme Court in criminal matters is defined. For that you have to go and research and get those grounds and the citations and cite it. As I have read in this Supreme Court Practice and Procedure, it is told that if you are mentioning case laws in the drafting paper, your marks are bound to increase. Therefore, it is not important that you cite the ground points, substantial question of law has arisen, or interest of justice, or sufficient cause. You have to get lots of groundwork on the cases that have discussed this elaborately, and you have to tell it, these cases that were discussed elaborately, in a similar manner, in my case also, such a situation has arisen. Therefore, the judgment that was cited in particular decision is applicable to my case. So, you have to do homework on that. Even though it is not very strictly required that you must cite for grounds, you are citing a particular ground on that, for example, delay, condemnation. If a ground is cited, government cannot delay too much. Lackluster attitude of the government is to be condemned. Then you have to cite that particular judgment of Supreme Court and tell this was how Supreme Court settled a particular point, and here also same thing is happening, and Supreme Court judgments are violated. Therefore, there is need for interference. So, in all drafting papers, you first need to show that there is a requirement of interference of the Supreme Court, and if there is a requirement of interference, you also need to know when the interference shall happen. So, what you need to write in all drafting papers, you must understand that Supreme Court is a third party always. Unless you invoke its jurisdiction, Supreme Court is just an edifice. It won't come to you. You have to go there. Okay, having gone there, why should the Supreme Court interfere? In appellate jurisdiction, it is on the basis of the impugned order. You must show that gross injustice, miscarriage of justice, all these things. For that, you have to have specific points. So, in the impugned order or in the facts, brief facts and statement of facts that are given to you already, there will be several instances where miscarriage of justice occurs, where interest of justice demands, where there is an administration of justice failure, where there is a justice demand failure. You must identify these areas. So now first you must, when you read a question paper, now we have got the question paper 2016. So what you must do, once you read the question paper, you must spend some 20-30 minutes on getting the 4 questions or 5 questions, whatever you have been asked to clear. First you must read it and get these main findings. You see, Supreme Court is appellate court mostly. It's not a original jurisdiction. In case of original jurisdiction, you have to show fundamental right violation or interest of justice in the transfer and the writ side. But in case of appellate jurisdiction, you have to show that the impugned order is perverse. Impugned order needs to be set aside. What is the only prayer in the SLP form 28? That the SLP needs to be admitted and the impugned order needs to be set aside. So why should it be set aside? So whenever you are drafting any question, the first thing you need to show is why should the impugned order be set aside. So that is the first aspect you need to concentrate. So you need to concentrate on the findings of the High Court that are against you and why they are wrong. So if you are just dilly-dallying and beating about the bush here or there, you are telling some other facts of the case, you are telling some other point that need not be put as the first point, then you are going to lose heavily. So the first thing after going to the question paper, what you have to do is analyze the findings against you. First mark the findings against you. Okay. So facts should be, okay, the question how should it be organized. First, this is general. Then I will go to the specific. Every question wise I will discuss 2 or 3 questions. First thing is, you must organize the facts. Findings first. What is the findings? Findings in your favor, findings against you. Okay. Have you done that? Next. Findings in your favor but not discussed by the High Court, but not applied in the judgment of the impugned order. And findings that are against you that have not followed Supreme Court principles set earlier.